Hello friends, today we will learn law of insurance. What is this? This is a law surrounding insurance. So, what do you mean by law of insurance? Insurance law is the practice of law surrounding insurance, including insurance policies and claims. What type of law is insurance law? Insurance is a contract in which one party, the insured, pays money called a premium and the other party promises to reimburse the first of certain types of losses, illness, property damage, or death if they occur. However, the term insurance law usually refers to the law surrounding private insurance. What is the purpose of insurance law? The practice of law surrounding insurance is majorly important both to individuals and the commercial sector. It primarily includes the regulation of the business of insurance, regulation of the content of insurance policies, and claim handling. What is insurance law PDF? Insurance is a contract between two parties whereby one party agrees to undertake the risk of another in exchange for consideration known as premium and promises to pay a fixed sum of money to the other party on happening of an uncertain event, death, or after the expiry of certain period. What are the main types of insurance? Life insurance, as the name suggests, life insurance is insurance on your life. Health insurance, health insurance is bought to cover medical costs for expensive treatments. Car insurance, education insurance, home insurance. What are the seven principles of insurance? To ensure the proper functioning of an insurance contract, the insurer and the insured have to uphold the seven principles of insurance mentioned below. Utmost good faith, proximate cause, insurable interest, indemnity, subrogation, contribution, loss minimization. What are the six principles of insurance? Principles of insurance: insurable interest, utmost good faith, proximate cause, indemnity, subrogation, contribution. What are the five legal principles of insurance? The legal principles of insurance that are generally applicable are discussed as follows: principle of indemnity, principle of insurable interest, principle of subrogation, principle of utmost good faith, principle of proximate cause. What is insurance law and contract of insurance? In general, an insurance contract must meet four conditions in order to be legally valid. It must be for a legal purpose. The parties must have a legal capacity to contract. There must be evidence of meeting of minds between the insurer and the insured, and there must be a payment or consideration. Now, what is the most important insurance principle? Indemnity. Yes, indemnity is a very important principle of insurance and stems from the value of the insurable interest. What is the subject matter of insurance law? The essentials for insurable interest are subject matter of insurance. Example of insurable interest is the interest which an individual has in the property which he owns. The insured must own an economic or financial interest whereby he will experience a financial loss if such loss occurs. What is section 38 of Insurance Act? A transfer or assignment of a policy of life insurance, whether with or without consideration, may be made only by an endorsement upon the policy itself or by a separate instrument signed in either case by the transferor or by the assigner, his duly authorized agent, and attested by at least one witness. What is section 41 of Insurance Act? No person shall allow or offer to allow either directly or indirectly as an inducement to any person to one, take out or renew or continue an insurance in respect of any kind of risk relating to lives or property in India, any rebate of the whole or part of the commission payable or any rebate of the premium shown. What is insurance risk law? Risk, uncertainty arising from the possible occurrence of given events. The insured or the property to which an insurance policy relates. What are the insurance laws and regulations in India? The main regulations that regulate the insurance business are the Insurance Act 1938, the Life Insurance Corporation Act 1956, the General Insurance Business Nationalization Act 1982, the Marine Insurance Act 1963 and the Motor Vehicles Act 1988. How many sections are there in the Insurance Act? There are 120 sections. The Insurance Act has 120 sections and 8 schedules. Under it, only an Indian company as defined and registered under Companies Act 1956 is allowed to operate in India. Which of the following laws would be applicable on the insurance? Answer is ACA is the right option. What are the four main types of insurance? There are, however, four types of insurance that most financial experts recommend we all have: life, health, auto, and long term disability. Some common types of insurance include health insurance, car insurance, life insurance, home insurance. How many types of policy are there? There are primarily seven different types of insurance policies when it comes to life insurance. These are term plan. The death benefit from a term plan is only available for a specified period, for instance, 40 years from the date of policy purchase. What are the characteristics of insurance? The characteristics of insurance is discussed under the following heads: a contract, undertaking of risk, a cooperative device, payment of policy amount on the happening of events, premium, contract of adhesion, development of larger industries, provide protection. These are the points. Which are the secondary principles of insurance? The second basic principle in insurance is insurable interest. Based on this principle, the insured has the right to insure an insured object due to the relationship of financial interest that is legal by law between the insured and the insured object. What are the basic principles of insurance? Read on to learn about the principles of insurance contracts: indemnity, contribution, insurable interest, subrogation, loss minimization, proximate cause, utmost good faith, get legal help with insurance contracts. What is principle of subrogation in insurance? subrogation is a part of all indemnity claims to make up the compensation paid. Your insurer can claim the insured right over that third party. You surrender your rights over the third party to the insurer. This transfer of all the rights and remedies from insured to insurer is called subrogation. What is the first principle of insurance? Principle of utmost good faith. The principle of utmost good faith is the most basic and primary level principle of insurance, and it applies to all kind insurance policies. What is good faith in insurance? The doctrine of good faith requires that both parties to an insurance contract must honestly disclose all relevant information as applied to the insurance company. This means honestly providing premium figures and coverage limitations. Applicants must truthfully disclose all requested pertinent personal information. What is the common law position with regard to the insurance principle of contribution? The insurer with the most specific insurance cover would be responsible for paying the claim and would not be able to seek contribution from the others. Now, what is principle of mitigation of loss? Mitigation in law is the principle that a party who has suffered loss from a tort or breach of contract has to take reasonable action to minimize the amount of the loss suffered. What is under section 45 of Insurance Act? No insurer shall repudiate a life insurance policy on the ground of fraud if the insured or beneficiary can prove that the misstatement was true to the best of his knowledge and there was no deliberate intention to suppress the fact, or that such misstatement of or suppression of material fact are within the knowledge. What is section 45 of the Insurance Act 1938? According to section 45 of the Insurance Act 1938, no life insurance policy can be called into question on grounds of misstatement or wrong disclosure after 2 years of the policy coming into force. However, If the insurer is able to prove that the claim was fraudulent, it need not be passed. What is Section 45 of the Insurance Laws Amendment Act 2015? Provided that the insurer shall have to communicate in writing to the insured or the legal representatives of nominees or assignees of the insured the grounds and materials on which such decision is based. What does Section 39 of the Insurance Act 1938 allow? The holder of a policy of life insurance on his own life may, when effecting the policy or at any time before the policy matures for payment, nominate the person or persons to whom the money secured by the policy shall be paid in the event of his death. Who is the number one insurance company? Here is the chart. These are approximate chart, but it may be changed by time to time. The largest auto insurance companies, we can see here the number one position, State Farm, and their market share percentage 16.73. In the second position, Allstate, and their market share 9.88. In number third position, Progressive 9.71, and in the fourth position, Jayco 9.49 market share percentage. But these all the datas may be changed by time to time. Now, what are the three types of risks? 1. Business risk. 2. Non-business risk. 3. Financial risk. What are another four types of risk? One approach for this is provided by separating financial risk into four broad categories: market risk, credit risk, liquidity risk, and operation operational risk. When can a policy lapse? A policy lapse occurs when the benefits and coverage provided under an insurance policy are terminated for a policy holder. A policy is lapsed when the policy holder misses the premium payments and the cash surrender value in case of permanent life insurance is exhausted. What is CSM in IFRS? A fundamental concept introduced by IFRS 17 is the contractual service margin, that is CSM. This represents the unearned profit that an entity expects to earn as it provides services. For example, new mismatches could arise between the measurement of underlying contracts and the corresponding reinsurance held. Why is IRDA important? IRDA, or Insurance Regulatory and Development Authority of India, is the apex body that supervises and regulates the insurance sector in India. The primary purpose of our IRDA is to safeguard the interest of the policyholders and ensure the growth of insurance in the country. What is the FDI limit in the insurance sector? The FDI limit in the insurance sector is 74%. Our country's parliament passed the Insurance Amendment Bill 2021 to increase the foreign direct investment limit in the insurance sector to 74% from 49%. What is the difference between IFRS 4 and IFRS 17? The key difference between IFRS 17 and IFRS 4 is the consistency of application of accounting treatments to areas such as revenue recognition and liability valuation. Profit recognition at the start of the contract. Revenue includes premium and may include an investment component. What are the three types of foreign direct investment? That is FDI. There are three types of FDI: horizontal FDI, vertical FDI, conglomerate FDI. What is PAA eligibility? For groups which contain any contract with a coverage period longer than 1 year, PAA eligibility is determined by applying a range of future scenarios that an entity would reasonably expect within the context of the particular group. What is fulfillment cash flow? Fulfillment cash flows is a probability weighted estimate of cash inflows and outflows that will arise as the entity fulfills the contract. Measurement of an insurance contract incorporates all available information in a way consistent with observable market information. Who is insured person? Definitions of insured person: a person whose interests are protected buy an insurance policy. A person who contracts for an insurance policy that indemnifies him against loss of property or life or health, etc. Synonyms: insured, type of individual, mortal, person, somebody, someone, soul, a human being. What is contract boundary? The contract boundary is defined as the point when the company can terminate the contract, refuse premium, stop paying claims, or change the premium so it fully reflects this risk, that is, at renewal or MTA stage. If there are contractual obligations to renew the policy, this must be included within the boundary. What is another word for insured? In this page, you can discover 27 synonyms, antonyms, idiomatic expressions, and related words for insured like safeguard, protected, covered, warranted, guaranteed, uninsured, underwritten, secured, assured, insured, and asserted.